If you or your family member have been charged with a crime in California State Court and have previously been diagnosed with a mental illness, you may be statutorily eligible for mental health diversion in lieu of prison time. Now, in 2022, the rules in California have changed, and now the court must presume that your mental illness contributed to the crime, meaning that the burden shifts and the prosecution now have to prove otherwise. Now, I've handled a number of these cases, and the question often arises whether the diagnosis can come after the crime. And the short answer is yes. Your lawyer can certainly send you to a mental health professional to be evaluated after the crime. And the diagnosis itself can happen even years after the criminal offense. So today we're going to look at one of the cases that was published just last week in California Appellate Court. And we're also going to look at the statute itself, which is 1001.36. Before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com/merch or shop.lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And if you get to the end of this video, I will tell you, you're going to hear this code one more time, but the code is mental health spelled together to receive 10% off all the merch on my website. Thanks for watching, and let's move on and talk about mental health.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a California appellate decision, the People versus Harlow. Now, the facts of the case are not super important as much as the timeline, but essentially Mr. Harlow and his neighbor got in the altercation where Mr. Harlow struck his neighbor with a skateboard on his body and his head. Now, he was ultimately charged with one count of assault with a deadly weapon in violation of California Penal Code Section 245. Now, all of this happened in 2020. In September 2023, so about 3 years later, Mr. Harlow files a motion for mental health diversion, which is based and supported on medical records and the diagnosis that he received 2 months prior from 2 qualified professionals. Now, in the trial court, his motion is denied. And essentially the court says the diagnosis came too late. It came years after the crime. And so the court says it clearly did not contribute to the crime itself. So he appeals the decision, goes up to the appellate court, who says otherwise. The diagnosis can in fact occur after the crime, and the statute itself supports it. So first, let's take a look at the statute itself, and then we'll do a little bit of analysis. A defendant is eligible for pretrial diversion pursuant to this section if both of the following criteria are met. The defendant has been diagnosed with a mental disorder as identified in the most recent edition of the Diagnostic and Statistical Manual of Mental Disorders, including but not limited to bipolar disorder, schizophrenia, schizoaffective disorder, or post-traumatic stress disorder, but excluding antisocial personality disorder and pedophilia. Evidence of the defendant's mental disorder shall be provided by the defense and shall include a diagnosis or treatment for a diagnosed mental disorder within the last 5 years by a qualified mental health expert. In opining that a defendant suffers from a qualifying disorder, the qualified mental health expert may rely on an examination of the defendant's medical records, arrest reports, or any other relevant evidence. And now the second criteria is the defendant's mental disorder was a significant factor in the commission of the charged offense. If the defendant has been diagnosed with a mental disorder, the court shall find that the defendant's mental disorder was a significant factor in the commission of the offense unless there's a clear and convincing evidence that it was not a motivating factor, causal factor, or contributing factor to the defendant's involvement in the alleged offense. A court may consider any relevant and credible evidence, including but not limited to police reports, preliminary hearing transcripts, witness statements, statements by the defendant's mental health treatment provider, medical records, or reports by qualified medical experts, or evidence that the defendant displayed symptoms consistent with a relevant mental disorder at or near the time of the offense. I know this was a lot of information, so let's simplify. Generally speaking, in order to get mental health diversion, you will need to have a diagnosis within 5 years of filing your motion with a qualifying and recognized mental diagnosis. What happens next? There's a presumption that your diagnosis, your mental illness, was a contributing factor to you committing the crime. And now the burden shifts. The prosecution has to prove with clear and convincing evidence otherwise. So that's essentially what the statute says. So to answer the question, when should the diagnosis happen? Well, anytime 5 years prior to you filing the motion, within that 5-year mark. Can it happen before your arrest? Yes. Can it happen after? Certainly. So the diagnosis can happen anytime as long as it happens 5 years from the date of your filing the motion, 5 years prior. That means if you're charged with a crime, you can certainly be evaluated by a mental health professional if you think you have mental health issues. So talk to your lawyer. You may still be eligible. Well, think of eligibility as getting a green light to apply. What does that mean? Just because you're eligible for mental health diversion doesn't mean that you're suitable. First, the court has to determine whether you're eligible. And here the appellate court says that the trial court got it wrong. They said that Mr. Harlow was never eligible. That's not true. Just because he was diagnosed after the crime, he was still eligible. The next question becomes whether Mr. Harlow is suitable. We never got to answer that question because the appellate court remanded the case back to the lower court. There, the court will now have to determine whether Mr. Harlow is suitable for mental health diversion. Meaning, is there a danger to the community? Is there a treatment plan? And whether Mr. Harlow is willing to participate in this diversion. I hope this answers the question. The idea behind the legislature was to expand mental health diversion. And we know this because even in the statute itself, the legislator tells us that the mental health professional can look at the criminal records, the arrest records, in evaluating Mr. Harlow. That means that if we only limited the timeline prior to the arrest, well, there wouldn't be any arrest records. So clearly, again, the legislator wanted to expand the program to include many more individuals than those that were diagnosed prior to their arrest. Again, the diagnosis can happen prior or after the offense. I hope you enjoyed this video. I hope you've learned a little bit about mental health diversion here in California. And if you did, give this video a thumbs up. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com/merch or shop.lawstache.com. And there you'll find the Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And again, if you've made it to the end of this video, your reward here is now if you go to my page, for all the products, you can put the promo code mental health as one word, and you will receive 10% off all the items. Thanks for watching, and I'll see you next Wednesday for another deep dive on another criminal case. you.